there. My name is Christine Jurusik, and I am a partner at Richards and Jurusik Immigration Law in Buffalo, New York. We practice mainly U.S. immigration law, but I have a practice where I focus on some Canadian immigration law, and I help people with DUIs and criminal convictions in the United States to enter Canada again after their conviction. Part of that is, making sure that people who are wondering whether they're admissible, finding out if they are, and then helping them to enter Canada eventually once their conviction is completed. Today, we're going to talk a little bit about what makes you inadmissible. There's many different offenses that can make you inadmissible to Canada. I know a lot of people have DUIs, but there's other ones that impact the situation as well. How time affects inadmissibility, with a certain amount of time passage after the conviction allows someone to enter Canada again. And then there's multiple ways that we can address inadmissibility to Canada through temporary resident permits, applications for rehabilitation, and we'll go over all of those ways. And then, even the deemed rehabilitation. So that is the one where passage of time will allow you to enter Canada. So we'll go over all of that today. So firstly, we want to know why something like a DUI or a criminal conviction outside of Canada would make you inadmissible to enter Canada. So, back after 9/11, Canada and the United States started sharing a lot of information with each other as we're allies, wanting to protect our borders. The United States knows a lot about Canadians coming into the United States, and Canada now is aware of criminal convictions and offenses that Americans have when they try to enter Canada. All of that really came to a head in about 2008. They really perfected that information sharing, which created a situation where people who were formerly traveling to Canada without any issue at all were calling me and saying, hey, I've been going to Canada for 5-10 years after my conviction, and all of a sudden I can't go anymore. And so all of that information sharing, the border officers know if you have a conviction, and they can determine that you're inadmissible and stop you from entering. But what criminal convictions really make you inadmissible to Canada? It's based on their law. So it's really happens because of the way the Canadian criminal law intersects with their immigration law. So their immigration law says that if you have been convicted of an offense outside of Canada, that if it happened in Canada would be something that would be on their criminal code, which is an act of parliament in Canada, a federal law, then you are inadmissible to the country. And unlike here in the United States, where DUIs and OVIs and DWAIs are all part of our vehicle and traffic law, in Canada, those alcohol and drug-related driving infractions are actually part of their criminal code up there and federal law, regulated by federal law. So having an offense like that on your record, the intersection with their immigration law makes you inadmissible to Canada. And so even one DUI can make you inadmissible. And frankly, the DUI rules really changed in 2018. December 18th, 2018, they changed the law up there. Prior to that, DUIs had been considered minor criminality. So the penalty for them was lower. People who had a DUI in the United States were considered just standard minor criminals, somebody who could possibly be absolved by the passage of time. But they legalized marijuana in Canada. And then when they did that, they raised the penalty for driving impaired up there. That took effect December 18th, 2018. So that the result is that anybody here in the United States that has a DUI is now considered a major criminal in Canada. And so offenses that happened after December 18th, 2018 are treated a little differently than older DUI offenses. And so, that's important information to have as well. Part of determining whether or not you're inadmissible to Canada requires us to perform an evaluation, an equivalency between the US law under which someone was convicted versus the Canadian law that, if it happened in Canada, they would have been convicted under. And that equivalency really needs to be performed by somebody who is familiar both with Canadian criminal law and US criminal law and criminal law of the state where you are. and frankly, there's a lot of people that are practicing in this area, Canadian immigration consultants that aren't really qualified to make that evaluation. So when you're looking for someone to help you with this, be careful. Make sure you're working with somebody who's a dual qualified lawyer in Canada and the US. They're going to be the ones that are best able to advise you on this. Okay, so why does a DUI make you inadmissible to Canada? Well, we talked a little bit about already why their immigration law, what their immigration law says, and how DUIs are a criminal offense in Canada. Um, that criminal inadmissibility applies to anyone who has been convicted of a DUI, OVI, OWI. I mean, there's many ways that states refer to this offense, but if it's an alcohol-related driving offense, even if it's not for a car, if it's for a boat, you could still be criminally inadmissible to Canada for an offense like that. Certain other offenses also make you inadmissible to Canada. So it's not just DUIs and DWIs, although we focus on that a lot because those seem to be very prevalent, in our clientele. But also reckless driving. So people, and I talked to somebody just recently who had a DUI, but they knocked it down. They were charged with a DUI. They knocked it down to a reckless driving, and they're still inadmissible. That's still an alcohol-related driving offense that would make you inadmissible to Canada. Other offenses include assault, domestic violence, theft and fraud, all of these offenses that are listed on this slide. Certainly drug-related offenses, controlled substances, things like that can still make you inadmissible to Canada. So you've got to be careful if you're traveling there. Make sure you talk to somebody before you go to find out whether or not you're admissible. And some of these offenses may be considered minor in Canada, even though they're considered major where you are. Certain things I'm thinking of are like our conspiracies and things like that. Sometimes we can do an equivalency and we can say, hey, you may think this is a major offense, but it's actually considered minor in Canada, and this person could be deemed rehabilitated. So it's important to talk to a lawyer before you go to understand your admissibility. The bottom number on this slide here, even dismissed charges or expungements may require an explanation. I would take that even a step further. So if something was dismissed, it doesn't necessarily mean that you're admissible to Canada. Sometimes there is a clause in their law that says that if you committed an action outside of Canada, that if it happened in Canada would make you inadmissible. And they can look on a balance of probabilities as to whether or not you committed that action, even if it was dismissed, that could make you inadmissible. Expungements, things like sealing your record, although that can help to demonstrate that you should be considered admissible to Canada, does not remove that charge from your record for as far as what Canada sees when you show up at the border. So if you really want to get an idea of what Canada sees when you're going to go there, I would encourage everyone to get an FBI background check done. You can have that conducted on yourself, get the results relatively easily, and that's going to show you what the Canadian authorities see when you show up at the border. So how do we overcome inadmissibility? There's 3 ways to do that. The first one, a temporary resident permit, or we like to call them a TRP. They are really, there's 2 ways to get one, and they're really for people that aren't eligible for criminal rehabilitation, perhaps because not enough time has passed yet. Frankly, they're for people that have a justified need to enter Canada. So for example, if you determine you're inadmissible and you have a relative in Canada who's ill, or a family member up there that needs to see you, you have an event in Canada, or you have a work reason to go, that's going to be an economic benefit to a Canadian company or client of yours, you can make a case that you should be allowed temporarily into Canada for a set period of time to complete whatever you need to do for that urgent situation. And what the officer is going to do is they're going to weigh the severity of your offense versus your need to be in Canada. So if you have a minor offense and perhaps not enough time has passed for you to be absolved of that yet, then and you have an important need to go, perhaps it's a business need. I had a client once that was going up to work on buses in Edmonton, and he was the only one that knew how to fix this problem. that's a pretty urgent and justified reason to allow someone into Canada. And so he was able to obtain a temporary resident permit to go to Canada for the week or 2 weeks that he needed to perform that work. The other way to, and I did mention there's two ways to get a temporary resident permit. You can make an application at the Canadian consulate. In the US, that would be the Canadian consulate in Los Angeles that adjudicates those. Just understand that if you are applying for a recreational reason, then that's going to take the consulate probably around 6 months to adjudicate that. That's not, something you're going to get quickly. You can make an application for urgent review if you have a justified reason. So something's coming up urgently and it is, your need for travel is important. And they'll look at those on a case-by-case basis. The other way to make a temporary resident permit application is at the border. So you can do it on your day of travel. So the day you're entering Canada, you can't do them in advance. You can do it on the day you're entering Canada, and you can ask the officer to issue a temporary resident permit if you're inadmissible. You should make sure you have certain paperwork with you in order to demonstrate your need to be in Canada, what happened with your offense, and showing perhaps a background check to show, whether or not you've offended at any other time in your life. So that's going to show them your full record. The other way to overcome inadmissibility that you would need to make an application for is criminal rehabilitation. And this is really the gold standard, because this is, once you have a determination of criminal rehabilitation, you don't need to reapply. It's not something you need to renew. It's not something you would ever need to do again, unless you were to reoffend, of course. It's a permanent solution. You are not eligible to apply for that until 5 years has passed since the completion of your sentence. So it's not 5 years from the conviction date. It's actually from the end of the sentence. So a lot of times when I'm talking to people, I'm asking questions about what kind of sentence they got, whether there was a probation, whether there was a license suspension or revocation, or if they had community service. When did that all wrap up? When was the last element? When did you pay your fine? When did you finish the probation? And we count 5 years from that date forward to determine eligibility to file for rehabilitation. Once that 5 years has passed, that application gets submitted in the US to the Canadian consulate in New York City. So it's different than where we would send the TRP application. And they'll make a determination. Sadly, right now, it's taking them about 2 years to adjudicate criminal rehabilitation applications. So you wait 5 years, you apply, and then you get to wait another 2 years for them to make a determination. And there really is no way to expedite that. Their response when we ask them to speed up processing is to say that if you have a reason to go to Canada, you should apply for a TRP while you're waiting for your rehab to be approved. And the final way that you can get absolved of your crimes and be allowed to enter Canada is deemed rehabilitation. So like the slide says, it's automatic. If 10 years has passed since the completion of your sentence, again, the end of that probation or the return of your license or whatever that last element is, you could be considered deemed rehabilitated. Deemed rehabilitation does not require you to make any application at all, but it only applies in certain circumstances. So for example, if you have only one minor offense, you can be deemed rehabilitated for that if 10 years have passed. But determining whether or not it's a minor offense requires that evaluation, that equivalency to Canadian law, and then counting that 10 years. If that happens, if you, for example, have one old DUI prior to 2018, and you wait for 10 years to pass from the completion of the sentence and you have nothing else on your criminal record at all, you could be considered deemed rehabilitated. And in that case, you should be able to go to the border and just show up there, and you should be able to be admitted to Canada without inadmissibility applying to your situation. Complications do arise, though, if border officers don't quite understand your situation. You don't have proper paperwork with you to demonstrate that. They could say, hey, you know what, you're saying you're deemed inadmissible to Canada, but based on our information, we think you're still inadmissible. So you want to make sure you talk to somebody before you go, determine that you're deemed inadmissible, and then have that or determine that you've got deemed rehabilitation, and then make sure you have paperwork with you to demonstrate that, just in case you get a border officer who's going a little off script. So what is a temporary resident permit? Well, we just talked a little bit about it. It's for urgent entry to Canada on a temporary basis. It's used in situations where you can demonstrate that you have a need to be there. A lot of times the way we present these applications is to show the need of the Canadian family member, business, what have you, that needs you to be there, okay? And that valid reason can be work, can be a family emergency, it can be an ill family member or friend in Canada. And the evidence you want to show is really demonstrating that need to be there, okay? And they're going to weigh that need versus the risk to the Canadian public of having you come to Canada. So, if you've committed a violent offense in the past, that risk is, that risk is a lot higher than somebody who has a non-violent offense. So that weighing of the severity of the offense versus your need really is a balancing act. It's important to talk to somebody before you go. And present a TRP. Perhaps your offense is considered relatively major in Canada, even though you think it's minor here in the US. And that equivalency would help you to determine that. Like the slide says, it can be requested 2 places. And I think we went over this briefly. The Canadian consulate, you can do that in advance. It takes about 6 months if your travels for recreation. It can be done faster for work or for a more urgent humanitarian need. Or it can be done at the port of entry. Perhaps you don't have time to wait 6 months for the consulate to adjudicate something like that. You can ask a border officer to look at this. They don't like doing it. So if you're planning to apply at the border, make sure you have all your paperwork with you and you're well prepped for that border interview. And then the validity period for a TRP. I know the slide says it's valid for up to 3 years. That's what it says on the books. I'll be honest with you, I rarely see them issued for more than a year, generally speaking. The longest one I've ever had has been 2 years, and that's for somebody who has a child in Canada that they need to see on an ongoing basis. And they were only able to get that 2-year TRP after getting a 1-year TRP a couple of times and renewing that. So your expectations should be a little lower than what it says on paper. 3 years, I think that's usually outside the realm of what we're generally seeing in this area. What is criminal rehabilitation? Good question. So this is the permanent solution. This is the option for people that have waited at least 5 years since the completion of their last sentence. They need to go to Canada. And they have the ability to wait 2 years for a determination. It's an application where they're going to weigh the severity of your offense. Again, is this a major criminality? Is it minor? How, was there any, violence involved, weapons, things like that, versus your rehabilitation factors. And those really look like things that you've done or changes in your life that have been made since you offended. So are you married? Do you have kids? Do you have a steady job? Do you own a home? Things that would show that you've made changes. Have you gotten a degree since then? Have you sing in the church choir? All of these things go to show the type of person you are now and perhaps a changed person from when you offended. And it also goes to show that you have things that would be at risk if you were to reoffend, right? So if you're a family person, you support your kids, you're not going to risk getting another DUI and being incarcerated and not being able to provide for that family. These things go to show that you're a different person and also that you're not going to reoffend. Once an application is submitted, which includes all of those rehabilitation evidence, evidence of what you did and what happened, and then showing you completed your sentence, the consulate will review that and they will issue a letter at the end of the process that says, hey, this person, we've adjudicated this, and this person is considered to be rehabilitated for this offense or these offenses. And then you can use that letter to travel to Canada. And if you're ever questioned on your admissibility for your past infractions, you're going to be able to show that letter. Once you're approved for rehabilitation, there's no need to get a temporary resident permit for these offenses anymore. Of course, if you reoffend, all bets are off. That criminal rehabilitation could be reinstated, and you would need to wait another 5 years and make another application. So the real way to get this resolved is once you get the criminal rehabilitation, don't offend again, because you're going to be starting over from scratch. And so, again, that TRP, that temporary one, no longer required once you have rehabilitation approved. Deemed rehabilitation is great when people are eligible for it. So we often look at the offenses and the timeline and things like that just to determine whether somebody is eligible for deemed rehabilitation. It only applies if you have one minor conviction in your past. If you have more than that, all bets are off, okay? So if you have more than that, deemed rehabilitation is probably not for you. You're probably going to have to make an application for rehabilitation in order to get allowed back into Canada. That one minor conviction, if at least 10 years have passed since the completion of the sentence, that's again, not from the conviction date, from the sentence completion. So I just talked to somebody the other day and they had their sentence was not completed until 5 years after they were charged with the offense because of the delays in the courts and, their attorney postponing the adjudication. And so that prolonging of the determination in this situation really pushed out their completion of their sentence. In fact, I don't even think it's completed yet last time I talked to them. So, it's important if you want to go to Canada, get things wrapped up quickly because you're going to want to start that timeline ticking. Looks like we lost our slide here. Mm-hmm. So with that deemed rehabilitation, I'll just talk without the slide, you wait the 10 years and then you should be able to go to Canada without doing anything. So you should be able to show up at the border with your passport. The officer, if they check and they see that you were convicted, should be aware that the timeline has passed. But oftentimes border officers, we can't rely on them to know everything. So I encourage people I talk to bring with you a copy of your disposition from the court, the judgment, a copy of if you had a probation or some kind of sentence, proof to show that ended, and then also an FBI report to show that you haven't committed any other offenses since this happened to you. And that will really demonstrate for them that you're deemed rehabilitated. If you get pushback, of course, we can do a deemed rehabilitation letter, or you can even, if you're really risk averse or you're having problems, make an application to the consulate for determination of deemed rehabilitation, where the consulate will lay out in a letter for you that they consider you to be deemed rehabilitated for this offense. And that will ease your passage to Canada going forward. Here we go, the slide's back. All right, so we have a little table here about when you would apply for a temporary resident permit versus rehabilitation. So if you look on the left-hand side, we've got a situation, someone who it's been less than 5 years, perhaps they had a DUI 2 years ago, but the sentence was finished a year ago, but it hasn't been 5 years since the completion of the sentence. The only option they would have is to apply for a temporary resident permit. They're not eligible for rehabilitation application yet. Someone who sentence was finished more than 5 years, but less than 10 years ago, they would be eligible for a temporary resident permit if they had an urgent need to go to Canada, or also for criminal rehabilitation. And a lot of times we file both at the same time because somebody's got an urgent need to go, but they also want to take care of this in the long term. And it's great to do that in conjunction because there's a lot of same information going into these application packages. Another situation, somebody's got 10 years since their completion of their sentence, and they only have one offense, and I'm going to add here that it's a minor offense. That person could be deemed rehabilitated for that offense. The determination of whether or not it's considered minor, again, requires someone to make an evaluation and equivalency between Canadian law and the U.S. law you were convicted under. So it's, it may be hard to determine that. And then another situation, if somebody has multiple offenses, keep in mind, we're counting the time from the last offense, okay? So those first ones, although they do make you inadmissible, the timeline we need is from the completion of the last sentence, that last element of your sentence to count. And if there's multiple offenses, people may be eligible for a TRP or criminal rehabilitation, depending on that timeline. So we've got some upcoming webinars that we're going to be hosting on L1A visas. Be sure to tune in if that's of interest to you. And certainly, if you need any assistance with entry to Canada, I'd be happy to talk to you. Give our firm a call, reach out by email, and we can do that equivalency for you and make sure that you're eligible to go for whatever reason you have to go to Canada.